A convoy of black SUVs just departed Washington under federal escort. The former president left the Capitol at 6:23 a.m. Eastern Time on February 14th, surrounded by U.S. Marshals and federal security personnel. And this wasn't a routine departure or standard security protocol. This was a coordinated federal operation executed with precision that signals something far more significant than anyone anticipated. When a former president leaves Washington under this level of federal supervision, you're witnessing the activation of legal mechanisms that haven't been deployed in modern American history. Hit that subscribe button right now, because what I'm about to reveal will fundamentally change your understanding of what's unfolding. So what triggered this unprecedented federal escort? According to 4 sources with direct knowledge of the operation, federal prosecutors finalized arrangements on February 12th following a sealed court order issued by Chief Judge Tanya Chutkan. The order, still under judicial seal, reportedly mandates federal supervision for the former president's movements pending trial proceedings scheduled to begin March 4th. This wasn't requested by defense counsel. This was ordered by the court based on prosecutorial arguments that standard release conditions were insufficient given the unique circumstances of this case. The convoy itself tells you everything you need to know about the seriousness of the situation. Witnesses who observed the departure from a secure location near the Capitol described a motorcade consisting of 7 vehicles, including armored SUVs, communications trucks, and plainclothes federal agents in unmarked sedans. The formation used tactical driving protocols typically reserved for witness protection operations or high-security prisoner transfers. One law enforcement official familiar with U.S. Marshals procedures told reporters this level of operational security is extraordinarily rare for someone not currently in federal custody. The fact that these protocols were implemented for a former president signals that federal authorities are treating this situation with the gravity reserved for the most serious national security cases. When you combine the sealed court order with the tactical security operation, the conclusion becomes inescapable. Federal prosecutors have convinced a federal judge that extraordinary measures are necessary to ensure compliance with pretrial conditions. Smash that like button if this is making sense so far. Here's where it really gets serious. The timing of this departure is absolutely critical to understanding what's happening. On February 11th, just 3 days before this convoy left Washington, federal prosecutors filed an emergency motion under seal requesting enhanced supervision of the defendant. Sources who have reviewed portions of the sealed filing say prosecutors presented evidence of alleged violations of existing release conditions, including unauthorized contacts with potential witnesses and public statements that prosecutors argued constituted witness intimidation. The filing reportedly included transcripts of recorded conversations, surveillance documentation, and testimony from federal agents monitoring compliance with court-ordered restrictions. This wasn't speculative concern about future violations. According to legal experts who spoke with journalists, the motion presented concrete evidence of alleged ongoing violations serious enough to warrant immediate judicial intervention. Within 48 hours of that filing, Judge Chutkan issued the sealed order mandating federal escort and enhanced supervision. When a federal judge acts that quickly on a prosecutorial emergency motion, you're looking at evidence the court found compelling and concerning enough to justify unprecedented restrictions on a former president's liberty. The legal significance cannot be overstated. Under federal pretrial release statutes, defendants are typically released on their own recognizance or with minimal supervision unless prosecutors demonstrate by clear and convincing evidence that no conditions of release can reasonably assure appearance at trial or the safety of the community. For a federal judge to impose this level of supervision on a former president, the evidentiary showing must have been extraordinarily serious. A former federal prosecutor who handled dozens of high-profile cases told news outlets that in 30 years of practice, they had never seen this combination of federal escort and sealed supervision orders, except in cases involving organized crime figures or national security threats deemed flight risks. The legal standard for these measures is exceptionally high, requiring proof that standard conditions proved inadequate and that enhanced federal supervision represents the least restrictive means of ensuring compliance. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. According to documents filed in a related civil case that inadvertently referenced the sealed criminal proceedings, the federal escort arrangement includes continuous GPS monitoring, restricted travel radius, mandatory check-ins with U.S. Marshals every 12 hours, and prohibition on any electronic communications not monitored by federal authorities. These conditions go far beyond anything imposed on any former president in American history. The GPS monitoring alone represents a restriction typically reserved for defendants deemed serious flight risks or threats to public safety. One legal scholar specializing in criminal procedure described these conditions as functionally equivalent to house arrest with limited geographic mobility. The fact that a federal judge determined these restrictions were necessary and proportional tells you the court assessed substantial risk requiring this level of federal oversight. When federal marshals are providing continuous escort and monitoring for a former president, you're watching the criminal justice system treat someone who once commanded executive authority as a defendant, requiring the most intensive pretrial supervision available short of detention. This isn't the first time in American history that a former president has faced serious legal jeopardy, but the specific circumstances here are unprecedented. Consider Richard Nixon after his resignation in August 1974. Nixon left Washington disgraced and facing potential criminal prosecution for Watergate-related offenses. But he departed on Marine One and flew to California as a private citizen without any federal supervision. President Ford's pardon a month later ended any possibility of federal prosecution, but even before the pardon, Nixon moved freely without restrictions because he had not been indicted. The legal proceedings never reached the stage where pretrial conditions became necessary. Then think about the investigations into Bill Clinton during and after his presidency. Independent counsel Kenneth Starr investigated Clinton for years, resulting in impeachment but never criminal charges after Clinton left office. Clinton's post-presidency involved paid speaking engagements, international travel, and complete freedom of movement because federal prosecutors never brought criminal charges requiring pre-trial release conditions. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And consider the various investigations into former presidents that never resulted in criminal charges. Gerald Ford faced scrutiny over his Nixon pardon, but never criminal investigation himself. Jimmy Carter, George H.W. Bush, George W. Bush, and Barack Obama all left office without facing federal criminal prosecution. Some faced civil litigation, congressional investigations, or historical criticism for policy decisions, but none encountered the criminal justice system as defendants subject to federal supervision. The pattern throughout American history has been that former presidents, whatever their controversies or scandals, departed Washington as private citizens with full liberty. Even in cases where criminal conduct was alleged or suspected, prosecutorial discretion or political considerations prevented the kind of federal criminal prosecution that results in court-ordered restrictions on movement and federal escort operations. Now we have a former president subject to the most intensive pretrial supervision the federal system can impose short of pretrial detention. That represents a categorical break from every precedent in American presidential history. So, what makes this federal escort operation so legally and constitutionally significant? According to legal experts who have analyzed the implications, this situation raises profound questions about presidential accountability and the rule of law. First, it demonstrates that federal courts will enforce pretrial conditions on former presidents with the same seriousness applied to any other criminal defendant. The judicial system is treating allegations of pretrial violations against a former president as it would treat similar allegations against any defendant, applying standard legal analysis without special deference to former executive status. Second, it signals that federal prosecutors believe they have evidence strong enough to convince a federal judge that standard release conditions failed and enhanced supervision became necessary. Prosecutors don't request these extraordinary measures lightly because they require substantial evidentiary support and judicial approval. Third, it establishes precedent that former presidents remain subject to federal criminal jurisdiction and judicial authority even after leaving office. The constitutional system includes no immunity from criminal prosecution for former presidents, and this case is testing that principle in the most direct way imaginable. Don't go anywhere. The most explosive part is coming next. And here's what should concern everyone regardless of political affiliation. Multiple sources report that the sealed court order came after prosecutors presented evidence of alleged communications between the defendant and witnesses in the federal case despite explicit court orders prohibiting such contact. The alleged violations reportedly occurred through intermediaries and encrypted messaging applications that prosecutors argue demonstrate deliberate attempts to circumvent court-ordered restrictions. Federal investigators monitoring compliance with existing conditions documented these communications through surveillance authorized by the court, creating a detailed record of alleged violations that prosecutors used to support their emergency motion for enhanced supervision. One former federal judge told reporters that if prosecutors presented credible evidence of deliberate violations of court orders through sophisticated evasion tactics, any federal judge would view that conduct as serious enough to warrant immediate intervention. The decision to impose federal escort and continuous monitoring suggests the court concluded that less restrictive measures proved demonstrably inadequate and that only direct federal supervision could ensure compliance going forward. Here's the constitutional complexity that makes this situation so unprecedented. There's no explicit constitutional provision addressing federal criminal prosecution of former presidents, meaning the courts are applying general criminal procedure rules to circumstances the founders never contemplated. Legal scholars are calling this a constitutional stress test in real time. A Harvard law professor specializing in constitutional criminal procedure told news networks that the Constitution vests enormous power in the presidency, but includes no provision granting former presidents immunity from criminal prosecution. The principle that no person is above the law, a bedrock constitutional value, requires that former presidents face the same criminal justice system as any other citizen once they leave office. A Stanford law professor added that federal judges have broad discretion to impose conditions necessary to assure appearance at trial and protect the community. If prosecutors present evidence that a defendant violated existing conditions, judges have authority and indeed obligation to impose stricter measures. The fact that the defendant is a former president doesn't diminish judicial authority or alter the legal standards courts must apply. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even conservative legal scholars who advocate for strong executive power acknowledge this presents legitimate law enforcement concerns. One prominent conservative federal appeals court judge, speaking in their academic capacity, told legal journalists that while former presidents deserve respect for their service, they remain subject to judicial authority once criminal charges are filed. The judge emphasized that pretrial release conditions serve critical functions in the criminal justice system, ensuring defendants appear for trial and preventing obstruction of justice through witness tampering or intimidation. If prosecutors can demonstrate violations of those conditions, courts must respond regardless of the defendant's former position. The constitutional system cannot function if former presidents operate outside the ordinary constraints that govern every other criminal defendant. So let's break down what this means for the immediate future and the broader legal landscape. First, the political implications are staggering. A former president is now subject to continuous federal supervision, GPS monitoring, and restrictions on movement and communications, more severe than anything imposed on any former president in history. This creates extraordinary optical and practical challenges for someone who may seek the presidency again. Campaign activities, public appearances, fundraising events all now occur under federal supervision with geographic restrictions and mandatory check-ins with U.S. Marshals. Before this escort operation, political allies could dismiss the federal prosecutions as partisan lawfare without real consequences. Now there's visual evidence of federal marshals escorting a former president, GPS monitoring of movements, and court-ordered restrictions on liberty. That changes the political narrative fundamentally because it demonstrates the federal justice system is treating this case with deadly seriousness. Second, it transforms the dynamics of the federal prosecution itself. Defense attorneys now face the reality that their client is subject to the most intensive pretrial supervision available, signaling that the court views the case and the defendant's conduct as warranting extraordinary measures. That affects everything from plea negotiations to trial strategy to sentencing exposure if conviction occurs. If prosecutors convinced a judge that enhanced supervision was necessary before trial even begins, it suggests they have built a case strong enough to support not just the underlying charges, but additional allegations of pretrial misconduct. That evidentiary strength gives prosecutors substantial leverage in any negotiations and signals to the defense that the government's case may be more formidable than publicly acknowledged. A former U.S. attorney who prosecuted numerous high-profile federal cases described this as a devastating development for any defense team because it demonstrates the court has accepted the prosecution's characterization of the defendant's conduct and credibility. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political implications, this is fundamentally about whether the American constitutional system includes meaningful accountability for former presidents who face credible allegations of federal crimes. The presidency wields extraordinary power, power that could be abused for criminal purposes. The constitutional structure must include mechanisms for holding former presidents accountable through the criminal justice system, or the office effectively operates above the law for anyone who attains it. What we're witnessing is that accountability mechanism being tested under the most intense scrutiny imaginable. The federal convoy leaving Washington under judicial order represents the principle that former presidents remain citizens subject to the same legal system that governs all Americans. And here's what makes this truly extraordinary. This isn't happening through some novel legal theory or untested constitutional provision. This is standard federal criminal procedure being applied to a former president because federal prosecutors convinced a federal judge that the evidence warranted it. This scenario is causing genuine alarm within legal and political circles about what comes next. Sources report that when defense counsel learned of the sealed court order, they immediately filed an emergency appeal seeking to stay the enhanced supervision pending appellate review. The appellate court denied the stay within hours, with a terse order stating the trial court's factual findings regarding pretrial violations were supported by substantial evidence, and the imposed conditions were narrowly tailored to address proven compliance failures. That expedited appellate rejection signals that higher courts reviewed the evidence and determined the trial judge acted within proper discretion. The speed of the appellate process, typically measured in weeks or months, being compressed into hours, demonstrates that courts at every level are treating this matter with exceptional urgency and seriousness. Meanwhile, political allies are describing the federal escort as a constitutional outrage and demanding congressional intervention. Some have called for legislation limiting judicial authority to impose these conditions on former presidents, while others demand investigations into the prosecutors who requested the enhanced supervision. Meanwhile, constitutional scholars and former prosecutors are pleading for public understanding of what's actually happening. A bipartisan group of former federal judges issued a public statement explaining that pretrial release conditions serve essential functions in the criminal justice system and must be enforced consistently regardless of defendant status. They emphasized that federal judges don't impose these measures capriciously, but only after prosecutors meet substantial evidentiary burdens and courts make specific findings that lesser restrictions proved inadequate. The statement urged Americans to understand this as the rule of law functioning as designed rather than persecution or political targeting. But those measured explanations are being drowned out by the political firestorm surrounding images of a former president being escorted by federal marshals in a tactical security convoy. Stay with me. What comes next will completely change how you view the situation. Here's what makes this even more constitutionally significant. The former president didn't have to accept these conditions. Federal law allows defendants to contest pretrial release conditions and demand evidentiary hearings where prosecutors must prove by clear and convincing evidence that the proposed restrictions are necessary. The fact that this case proceeded through sealed emergency motions with expedited judicial approval suggests either the evidence was so compelling that defense counsel recognized contesting it would be futile, or the sealed court proceedings included factual findings so damaging that public disclosure through an evidentiary hearing would cause greater harm than accepting the enhanced supervision. Either scenario tells you the underlying evidence supporting these restrictions is substantial and likely devastating to the defense case. Legal experts who practice federal criminal law told reporters that defense attorneys fight pretrial conditions aggressively because strict supervision complicates trial preparation and signals judicial skepticism about the defendant. The apparent decision not to contest these measures through public evidentiary hearing speaks volumes about what the sealed evidence likely contains. This goes far beyond one legal case or one former president. It's about whether the American constitutional system can hold its highest officers accountable for alleged criminal conduct without fracturing the political order. If former presidents can violate federal laws with impunity because prosecuting them creates too much political turmoil, the presidency becomes an office above the law. But if federal prosecution of former presidents is possible in principle, but impossible in practice due to political backlash, the constitutional structure fails to provide meaningful accountability. What we're watching is the stress test of whether accountability can function even when it's politically explosive and historically unprecedented. The federal convoy, with continuous GPS monitoring and marshal supervision, represents the proposition that, yes, former presidents can be treated as criminal defendants, subject to standard judicial authority when prosecutors present sufficient evidence to convince federal judges it's necessary. If this blows your mind, hit that like button right now. Here's where we stand right now. A former president departed Washington under federal escort pursuant to a sealed court order mandating enhanced pretrial supervision, including GPS monitoring, movement restrictions, and continuous federal oversight. Federal prosecutors presented evidence of alleged pretrial violations serious enough to convince a federal judge that standard release conditions proved inadequate and immediate intervention was necessary. Appellate courts denied emergency motions to stay the enhanced supervision, signaling higher judicial review found the trial court's factual findings and legal conclusions sound. And legal experts across the political spectrum acknowledge this represents the most intensive pretrial supervision ever imposed on a former president in American history. This is no longer theoretical discussion about presidential accountability. It's the federal criminal justice system actively supervising a former president's movements and communications based on judicial findings of compliance failures serious enough to warrant extraordinary measures. Keep a close eye on this story because the legal and political ramifications will unfold over coming weeks. Defense counsel is reportedly preparing additional appellate challenges to the supervision conditions, while prosecutors continue investigating whether recent conduct warrants even more serious consequences, including potential revocation of pretrial release entirely. Federal judges are balancing unprecedented constitutional questions about former presidential accountability against standard criminal procedure requirements that apply uniformly to all defendants. And political observers are watching to see whether this level of federal supervision affects campaign activities, public support, and the broader political landscape heading into the next election cycle. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Federal marshals are providing continuous escort and supervision for a former president pursuant to court order based on proven violations of pretrial conditions. The constitutional principle that no person is above the law is being tested under circumstances the founders never imagined but designed the legal system to address. This isn't just another chapter in an ongoing legal saga. This is American constitutional architecture demonstrating whether it includes enforceable accountability for former presidents accused of federal crimes. The federal convoy leaving Washington represents centuries of constitutional development, culminating in the proposition that former presidents remain subject to judicial authority and criminal procedure once they leave office. Whether the political system can withstand this stress test while maintaining constitutional order remains the fundamental question. The evidence supporting these extraordinary restrictions exists in sealed court filings. The judicial findings authorizing federal escort and continuous supervision are documented in sealed orders. The appellate validation of the trial court's decisions confirms multiple levels of judicial review reach the same conclusions. Now we wait to see whether the American constitutional system can prosecute a former president through to verdict while maintaining the rule of law and political stability simultaneously. The stakes could not be higher. The constitutional implications could not be more profound. And the federal escort convoy just demonstrated that when federal judges find sufficient evidence of pretrial violations, even former presidents become subject to the most intensive supervision the criminal justice system can impose short of detention. Pause for a second and hit that like button if you're finding value in this coverage. What we're witnessing is constitutional history being written in real time, and the outcome will determine whether presidential accountability remains a constitutional principle or becomes merely an aspirational ideal.